Okay, it being 7:30, the chair will now convene our regular meeting of the board, and the first case I'm going to call is case number 07941, 269 and 273 Putnam Avenue. This is the case brought by Sarah Sept, second case involving the same address. Anyone here wish to be heard of this now? Yes. Name and address to the stenographer, please.
My name is Neil Hartson, H-A-R-T-C-E-L-L, and I'm at 1 International Place.
Spell your name again?
H-A-R-T is in Tom, C is in C-E-L-L.
The floor is yours.
Good evening. Thank you for I represent Sarah Smith in the city of New Mexico.
Mr. Chair, could you ask the petitioner to speak up?
Sure.
If anybody is having trouble hearing, you're free to come behind us and hear, or hear better than you are in the audience. We have to apologize for this room. It's not designed for people in the audience to hear very well, but this is all the city will give us. So, anyway, now you can go ahead.
I'll do the best I can. Sarah Smith lives at 267 Putnam Avenue in Cambridge. And pursuant to General Laws, Chapter 48, Section 7, on June 25th, Ms. Smith petitioned the Inspectional Services Department with respect to a number of violations of the ordinance on 2 contiguous lots next door owned by Mr. Mastrangelo, by Mr. Mastrangelo. Her property abuts those 2 lots. And on the notice of appeal, on Exhibit A to the notice of appeal, we've attached the letter to the commissioner. And we wanted some action taken with respect to the violations of the ordinance on these 2 lots. And let me just walk you through what they are, because it's important as to why they're here. The problems with the 2 lots include, limited to, the construction and use of a full-fledged retail establishment and an apartment that we believe is illegal in contravention of his July 5th, 1994 application for a variance to build what was then called a garage and office space. The construction, we don't believe we haven't been able to find a building permit. In the apartment, there's a lack of a second egress. There's the construction of a porch and parking space with virtually no setback from her property line. There's a retail sale and consumption of seafood and outdoor seafood located on both lots without proper zoning and licensing. And the construction of 2 wooden sheds that virtually abut the property lines, which we also believe are in violation of the setback. In addition, over one of the picnic tables areas, there's a roof that's being constructed that extends from 269 Putnam Avenue all the way to her property line. And that's supported by a 9-foot solid wall. And in addition, the vent fan that comes out the back of this, what was supposed to be an office, is going shortly before they open, which I believe they open around 11-ish, right, in the morning. And it goes until they close.
Is that a zoning violation?
If it's an office, I don't know why you need a vent pouring out.
No, is a maintenance of that fan a zoning violation?
Yeah, but I think it is.
And what's your authority for that?
Because this was not what this property was, what the building permit applied for. It's in a residential area. And I don't think you can write.
I think the essence of your client's complaint is really twofold. That there is a illegal, I guess, operation of a restaurant and seafood business, with a business use in the residential district. Yes. And the second is the illegal apartment. Everything else is bells and whistles around. That's the crux of the
those are the 2 central issues. I would absolutely agree with you. But the other problem are these sheds that violate the setback. So, in any event, after we sent the letter to the commissioner, he sent out a cease and desist order. Terrific, great. That's what we would expect the commissioner to do. However, I don't know what happened, but the issues about the zoning setbacks and the apartment and the lack of egress, none of those were addressed. And one of the reasons why we're here tonight is because we believe the time was ticking, and those hadn't been addressed, and we wanted to make sure we were preserving our rights, and so on. So that's why we're here tonight. If I could just spend a couple of minutes talking about what's happened over time with the property next door. Originally, it was built as an office, and there was, I think, a garage to be used for storage and whatnot, and an office for his work. And we attached portions of the hearing transcript from 1994 when that occurred. And what happened was, I was certainly not there, so I'm just giving you what we've got from documents and so on. He started selling lobsters from a truck outside. Okay. But then tanks were put in the storage space, supposedly, in the garage. And then lobsters started to be sold out of there. And then at some point later, which we think was around 2005, I could be wrong on that date, they started cooking things and selling these lobster sandwiches. And what's happened over time is it's been a general creep of the garage selling lobsters out of the truck to now a full-blown operation. It's got a loudspeaker going on, calling out orders all day long. Trash is blowing around. The exhaust fan is emitting noise and smells and so on and so forth. And the customer has been creeping closer and closer. Right now, there's picnic tables right outside Ms. Smith's living room window. And I mean, they're as close as you can
interrupt you, but you're just elaborating on the fact that the restaurant and retail use, that was one of your major
Yes.
maybe I don't know, a major complaint.
A major complaint.
A major
That's
complaint.
Correct. That's correct.
An enforcement letter was sent out.
Yes.
Telling the petitioner, the owner of the property, to cease and desist. Are you aware that the city has now filed criminal action?
I was not aware.
Okay.
I was not aware.
I know one of your complaints in your appeal is that basically I'm going to use my own words, the commissioner has not been vigilant enough, or the city has not been vigilant enough in enforcing
Well,
it.
if they file a criminal charges,
Yep.
that's a different issue. And to the extent that we are claiming they should have taken additional action, it sounds like they've done it. I haven't seen it, I'm not aware that you just said it.
I'm a little confused about what you're appealing.
Yeah, that's what I'm
Okay.
getting at.
Fair enough.
Good.
Initially, we were concerned that the city wasn't taking strong action. It now appears that they have. That's great. What we were appealing also was the fact that in addition to the retail operations at the Lobster, we have these setback violations. There are these structures that are built right up next to her property. And his letter, the commissioner's letter, didn't address those. And so because the clock was running under the time for us to take action, we felt we had to take an appeal to preserve our rights.
If we were to tonight vote with regard to those issues, if you've identified the setbacks and like that your appeal rights have been preserved, but we're not going to hear the case further until after the court proceedings on major issues regarding the property, the restaurant operation, the illegal apartment have been decided. Will that satisfy you? I don't want us to go into all these little details if the crux of the case is going to go away. If it's going to go away. If the criminal proceedings,
As long as our rights were preserved,
Yeah,
to
yeah.
deal with those, then I would be comfortable with that. I mean, as long as the city's taking serious steps to address it, that's what we want, so that's terrific.
I will
we
ask the
don't
board
wanna-
to make a motion that all of the rights that were set forth, all the complaints that were set forth in your letter to to inspectional services, to the extent not addressed in the cease and desist order in the court proceedings, are preserved. And therefore, if it becomes necessary at an appropriate time in the future, you can come back before us, and we'll decide those on the merits.
So they're preserved pending the outcome of the criminal charge?
Yes.
That's fine. I'm comfortable.
Is there other than the members of the board?
It sounds about right.
Good. Okay. Okay, the chair moves.
That would include the apartment?
I'm not sure. The apartment is subject to a cease and desist order, but the litigation doesn't mention the restaurant, the apartment, which is a little puzzling. This is,
Well, what I think happened, with all due respect to the commissioner, is they may have been focused on the restaurant and perhaps overlooked. I don't know.
yeah, well, I can always read that. The cease and desist letter does specifically cover the apartment. So
Does or does not?
does.
The apartment and the business.
And those are the two things. So I guess both the city at some point can go go ahead and file a second complaint and deal with the apartment if it wishes to do that.
And they could file, inspection services, the commissioner could still file an additional complaint about all those other things you just listed too.
Yes.
Right?
Yeah,
And you could do it in a timely manner where, you know, your right to appeal must be infringed. I don't know how long,
Well,
I don't know how long it's been taking.
I think the clock has already run,
Oh,
but
okay.
I don't know why he couldn't continue. I don't know why
No,
he couldn't.
so we preserve your right to do that. He can issue another, letter about those other complaints if after the inspectional services department inspects the property and decides that in fact those are legitimate complaints, encroachments on setback and whatever, illegally built sheds or whatever, and that should preserve your ability to go forward if this thing isn't resolved in a manner that's satisfactory.
If I may, just one other thing. I was just saying, if there's some additional signatures on some letters from some abutters.
I'll take that next time. Thank you. I'm sorry.
No, I'm all set.
Anybody here wish to comment on the case? I think you see where we're going with this. We're not going to grant the appeal. We're just not going to make sure that these individuals or the neighbor has lost any rights. I think we all going to think that the case is proceeding the way it should proceed. That the major issues that were raised by the complaint were dealt with by inspectional services and are now in the courts. But anyway, Mr. Rafferty, if you want to speak.
Thank you, Mr. Chair. Sure. I'll pull a chair. For the record, my name is James Rafferty. I'm an attorney for the law firm Batten & Rafferty at 675 Mass Avenue in Cambridge. I represent Louis Mastrangelo, who's seated in the front row, along with my co-counsel, Odin Anderson. I just wanted to raise a couple of procedural issues before the board. I certainly understand the wisdom of the approach here. I shared the surprise when I learned of the appeal because I can attest to the fact that there has been an enforcement action taken, and in fact, as the board is aware, the next case involves my client's appeal of that enforcement action. But it is worth noting, since counsel here is establishing positions on the record, that Section 7 of Chapter 48 allows persons, anyone essentially, to allege a zoning violation. And zoning violations then get reported to inspectional services and appropriate action is taken. Appeals from those enforcement actions or requests, however, are limited to persons aggrieved within the meaning of the statute, Section 8. Now, as an abutter, it's the same standing position that applies in Section 17, variance or special permit appeals. As an abutter, the applicant in this case certainly enjoys what's considered the presumption of standing, but it's a well-settled principle in land use law that one needs to be able to demonstrate that a person agreed in order to meet the standard to proceed to this level with the appeal. And this applicant is not aggrieved in this case because she does not have an interest in preserving the integrity of the zoning district because she operates an illegal use at her property. So what's described as a living room is the room of a hotel that is operated at this property.
I don't want to get into that.
I suspect you didn't have much tolerance for it, so I'm going to keep it very limited, but just wanted to establish on the record serious questions as to whether or not this applicant meets the standard of a Section 8 person aggrieved, given the manner in which she uses her own property.
Thank you.
Thank you.
If I may respond very briefly, sir. It's true that Ms. Smith runs an in-home bed and breakfast. There's nothing illegal about it.
I don't want to get into the merits of that. That's
I
just
just want that
property.
on the record. There's no issue from our perspective.
Okay. The other thing I'm a little puzzled by, Mr. Rafferty, is the notion of standing and a person aggrieved. I'm not sure it applies in the kind of the case we have here. It seems to me any citizen of the city who believes there's a zoning violation has a right to go to inspectional services department.
Agreed.
And then inspectional services department takes it from there. Either they throw it, they don't pay attention to it, or they do what they've done, cease and desist. So I don't know why. I'm not sure where you're going with your agreement.
Because this property owner has appealed the enforcement action
Right.
to this board.
Got it.
And to be before this
I get
board,
it now.
on that appeal, one needs to be a person aggrieved, and we're raising the issue that this applicant in this case is not a personal grievance.
Now I understand your point. I'm slow tonight. But I still think that given the fact that I'm going to continue, we're going to wait till the outcome of the criminal complaint, and then all rights are going to be preserved all around. And if this case continues after the court proceedings are there, well, then we'll take up your issue. I don't want to take it up tonight.
No, I understand. And just to be clear, the next case could be dispositive, which might then make the issue in the courts. I mean, the board is about to hear an appeal of that. So it's also possible that the termination in that case could have impact on this. It's not limited to, the presumption here in this case is that that the board has reached a conclusion in Mr. Mastrangelo's appeal. And I know that hasn't happened yet because we haven't heard that case yet.
Okay. Well, if we grant your appeal or your client's appeal, and then this case now all of a sudden is no longer moot, then we'll continue the case for a couple of weeks, and we'll hear the rest of the case in the full appeal. But for right now, I think there's no need to do anything more than to get, unless you feel otherwise.
No, I feel completely comfortable. I think it's a very prudent and efficient approach the board is taking with the case.
Okay, thank you. Kevin, yes, sir.
Just so the record's clear,
Sure.
the statement about illegal use is completely
Say
factual.
what?
The statement of an alleged illegal use by my client is factually inaccurate. I know that. I just want to say it for the record.
Okay. It's
Well,
on the
for the
record. It's
record,
on the
it's not.
record. What?
It's a two-family, I'm not going to take any more time because
No, it's
I
on the
wouldn't want to
record.
jeopardize my position in the next case by annoying you in this case.
You've already done that. It's lost.
That occurred months ago, years ago.
Okay, the chair moves that, don't go yet. Forget to I'm referring to this motion. The chair moves that this appeal be held in abeyance pending either the outcome of the court case that has been filed or the next case we're going to hear involving the owner of the property in question position that this appeal, that there's no zoning violation given these, I want to call the statute of limitations is run. So, but until then, until either one of those things happens, the court case gets decided, and we decide in favor of the applicant in the next case, everything is status quo. You have your rights, and if need be, at a future date, you come back before us, and we'll hear this case out on its terms. All those in favor of that motion, say aye. Aye in favor.